Section 10 of the Act covers confidentiality. Could you tell me a bit more about that?
Yeah, well, this is an important provision, obviously. So it means that, the confidentiality of the mediation process is now actually enshrined in law, which is a good thing overall, as confidentiality is one of the key hallmarks of the process. However, the way it's drafted is a little bit unusual. So confidentiality is defined by reference to communications, and communications is the word that is used. And this is defined as including oral communications, records, and notes. And it provides that such communications are not to be disclosed, whether that's before a court or otherwise. And, obviously that includes whether you're telling your granny or posting it on Facebook or, broadcasting what happened in mediation from the rooftops. That is all prohibited by this Act. There are a few exceptions to this, and it's worth looking at those. These are not unusual when you compare them to exceptions set out in mediation laws in other countries and indeed in the EU directive. So the exceptions are where disclosure of these communications is necessary in order to implement or enforce the mediation settlement, where it might be necessary to prevent either the psychological or physical injury to the party or to somebody else, where it's required by any other law, in order to either prevent or reveal the commission of a crime or a threat to an individual. And if you found yourself in the awful position of being a mediator against whom a claim of misconduct or negligence is made, obviously the confidentiality can be lifted in order to prove or disprove a claim to that effect.
Okay.
What is interesting about how it is framed is that the provision doesn't specifically refer to who is covered by this provision. So it defines what kind of communications are covered, but not whether this confidentiality obligation is only on the mediator and the parties, or as we would generally say, to anyone involved in the mediation process. So a kind of a flag there for both solicitors and for mediators is to ensure, and particularly for mediators, that in your agreement to mediate, my own recommendation would be to set out whom this confidentiality obligation applies to, and to ensure that anyone who's involved in the process, including those non-party participants whom we spoke about earlier on, sign in agreement to mediate, guaranteeing that they will not go and speak about what happened in the mediation. And I, in my own experience, a lot can turn on that sometimes, where non-party participants might, think that they're not bound by confidentiality and might seek to disclose information that came to the fore in a mediation. So just something to be a little bit careful of, to make sure that you back up this provision with the provisions in your agreement to mediate.
Okay, just a question on the confidentiality and communications. What are the obligations on any notes that you take to retain those notes as a mediator?
That is not set out in the Act. I imagine there is a forthcoming piece of data protection legislation that might and might not address record keeping and notes that will also pertain to mediators. But there are no specific obligations in relation to note retention in the Mediation Act. Generally, mediators in Ireland would take different approaches. Many will destroy their notes once a mediation is terminated. Some will keep their own notes for a period of, say, 3 years or 6 years. But there's no general guidelines set out in this piece of legislation in that respect. The only thing that is clear is that such notes come within the Section 10 definition of confidentiality and therefore can't be disclosed before a court or otherwise.
Can't be, or
cannot be.
Cannot.
And I would have had occasions in the past where maybe a lawyer might have written to me after an unsuccessful mediation and said, could you please send me your notes or the minutes of the mediation? And I've had to rely on my agreement to mediate to say, no, I can't. Now, at least the act is there that says any of such communications are off the record and can't be disclosed unless they fall within one of the exceptions.
Okay.
Yeah.
Good. Okay.